Good morning, good afternoon, good evening, wherever you're dialing in from. Welcome to the latest in the Fieldfisher Silicon Valley data protection series. Today we've got the topic of data protection post Brexit. We scheduled this session for 27th of March because we thought there would be some certainty about what's happening with Brexit by then. For anyone who's following the news, that's obviously not the case. So yeah, if you're listening to this on recording, you can probably stop now because the landscape's probably all changed. So in the room with me today in Silicon Valley is Mark Webber, managing partner of our Silicon Valley office, and my long-haired friend Alexander DeGay, an associate in the team here.
Hello.
And I am Alden Takitimi, a senior associate here. Also joined on the line from LA by Yuli Takatsuki, who is a director in our team here. So,
hi everyone.
In terms of what we're going to cover today, we're going to go a little bit through the background as to what got us here, what the current status is with Brexit. We're not going to major too much on the political machinations which are happening right now, actually, because the things are changing so much in that space. And then we're going to talk a little bit about what the three main scenarios are of Brexit. Either we're going to stay, we're going to leave with a deal, or there's going to be a no deal Brexit, and then what each of those scenarios mean from a data protection perspective. And just before I hand over to Yuli to talk to us a little bit about the background of how we got here, just a plug for our next webinar, which is going to be on April the 25th, and I think it's going to be about revisiting negotiating DPA sort of 1 year or so into GDPR world. All right, so on that note, Yuli, tell us about how we got here.
Thanks, Eldon. Yeah, so like Eldon said, there's the feedback we're getting from a lot of our clients is that they feel a little bit lost as to what's actually going on with Brexit, and that's entirely understandable given the pace at which everything keeps changing and going back and forth. So we're not going to go deep into the political noise, just some basic facts about what you really need to know about what's happened so far and where we are today. So where did it all begin? Well, almost 3 years ago now, June 2016, there was a referendum, which is essentially a direct public vote, in which 52% of the UK public decided to leave the EU.
On my birthday, Yuli.
Oh, very important point. Yeah. Alex's birthday. Yeah. But the referendum was really only the beginning, because what then happens is that the Prime Minister, Theresa May, she needed to trigger Article 50 of the Lisbon Treaty. And essentially, Article 50 gives any European member state the right to quit unilaterally from the EU. And then by invoking it, you set off a kind of chain of events by which the UK formally leaves the EU. And that gave both sides 2 years to reach an agreement about how the UK is going to leave. And that was due to expire, as Eldon said, this Friday, 11 p.m. UK time. So lengthy negotiations took place about the terms of this sort of withdrawal agreement. But the issue with the withdrawal agreement was that it needed to be approved by the UK Parliament. And once approved, if all going well, there was going to be this sort of transitional period until the 31st of December 2020, in which things pretty much stayed the same, and the UK leaves in an orderly fashion, and both sides spend another chunk of time hammering out the terms of their longer term relationship and what happens after that transitional period. But things didn't go quite to plan because the withdrawal agreement contains a lot of controversial issues, which we won't go into now. But the pivotal point has been around the border between Northern Ireland and the Republic of Ireland. So fast forwarding to 2019, the withdrawal agreement was put to a vote by the UK Parliament, and it was categorically voted down, essentially, in both January and March of this year. So as things stood, the UK was at risk of leaving the EU without any deal in place, the so-called cliff edge scenario. But thankfully, the EU agreed to a short extension of time to the 12th of April, just to enable the MPs to vote again on the Prime Minister's deal. So, Mark, I might hand over to you about sort of where we are today. Just one point, which is that on Monday this week, there was a kind of unprecedented political move, which was that the British Parliament, they were sort of dismayed by this idea of voting for a third time on essentially the same deal. And so they voted to take control over the parliamentary process. And they wanted to decide what motions should be voted on for Brexit. So now, under the new plan, the MPs are going to put forward their proposals for what Brexit plans should be voted on, and then they can hold a series of votes, which is sort of designed to test which Brexit path commands the greatest majority.
Thanks, Julie.
Yeah.
So I think that sort of brings us up to date. Mark.
Yeah. So and as Julie says, this series of votes that's taken place as a result of the UK Parliament wresting control is actually commencing as we started this this webinar. So we'll be finding out where some of that it's going over the next 2 days. I think the big problem with a lot of this Brexit planning for the government is within Parliament at the moment, there's no real overall majority. And within the parties that comprise the UK Parliament, there's not necessarily voting along party lines. So a number of the outcomes are questionable. And that's why we've managed to bring ourselves down to the wire in the UK. And we were leaving the EU on the 29th of March, and that's been written into the UK law for some time now. But what we got to on the 22nd of March was a new kind of compromise from the EU, who still have a vested interest in getting this all right. So rather than leaving on the 29th, the Prime Minister now has, or the government now has, until the 12th of April to get a new deal through. At which stage we would leave the EU. If there's no approval from those MPs, then we would delay to the 22nd of May and leave on the 22nd of May, potentially with some kind of new deal or with some kind of Brexit. That 22nd of May deadline is interesting because the European Parliament elections take place between the 23rd and 26th of May. And if the UK is going to continue in the EU, we need to have representatives within that parliament. That EU Parliament election is significant in privacy sense as well, because that's also going to determine potentially the body of EU Parliament that's going to be driving through something like the e-privacy directive. So we're looking at a number of alternative dates now, the 12th or the 22nd, or some kind of long extension. And somewhat ironically, although we're not allowed to have another referendum, according to the government, we can vote on their parliament, their terms a number of times. And Theresa May is now trying to either get her deal through to kick off the withdrawal period, or, as Julie was saying, we're looking at these confirmatory votes where we're just trying to get some kind of indication from Parliament whether there's a majority for one type of Brexit or another, be that softer type of Brexits like membership of a customs union, membership of a common market 2.0, EFTA or EEA trading relationships, perhaps having another confirmatory referendum, perhaps revoking Article 50 altogether, and looking other kinds of compromises. So we'll be looking to see whether they can bring some kind of majority around those kind of formulas. I think either way, when we were planning this webinar, the team kind of breaks it down. We're still in 3 real scenarios.
Yeah.
We're looking at a hard Brexit, where we fall out of the EU without a plan and without a deal. And that would probably be the most disruptive from a privacy perspective. We're looking at a scenario where we come up with some kind of deal, and that deal kicks in either now or in a delayed future, giving this softer environment where we're effectively still in the EU with EU rules, albeit with a longer term date to leave, or we end up staying and never leave. And I think we really need to talk through these 3 scenarios in order to understand the privacy implications of them.
Yeah, perhaps if we can do it backwards, if we could start with the stay in the EU.
Well, I
option.
conveniently arranged the slides in just that order. You'll be pleased to know.
Very good.
Yeah. So, staying in the EU. Well, in that sense, there isn't really much change. The UK would remain a member of the European Union. The ICO, the UK regulator, would remain one of the supervisory authorities under GDPR. The GDPR would continue to apply directly in the UK, as well as the UK's own national legislation. Those organisations who thought about their lead supervisory authority being the UK one would be able to continue to rely on that. The ICO would still sit at the table of the European Data Protection Board. Those who put a DPO, a data protection officer, and based in the UK, that would still be a sound plan because they'd still be in the EU. And all Europeans would be happy because they could still live there and everyone would live in harmony forever. I think it sounds nice.
The end. How do we vote for that one?
Well, ask the 6 million odd people who signed that petition, but you know,
Yes.
the message from Theresa May is that that is not one of the realistic options. So, unfortunately, but from a data protection perspective, that's the simplest one. The status quo remains and nothing changes.
Right. So what about the transitional arrangements?
So from my position,
Whatever that deal looks like.
whatever the deal is, exactly, yeah. So it will be relatively similar in that the transition period, I mean, certainly the withdrawal agreement as it's drafted, will essentially keep the status quo for that fixed period of time. Currently the end of 2020, although that's relatively tight to negotiate a proper free trade deal and all the other complications, given that these things take so long. But essentially it's a kind of temporary status quo in order to buy time to sort out the future relationship. So all the other things.
And just on that, on those various things that are being negotiated, where do we feel like data protection sits in the grand scheme of things?
Well, we obviously as data protection lawyers feel it's very important, but we're not alone, because when early on in negotiations, when Theresa May set out 5 priorities for the future relationship, one of them was data protection, which we were all very pleased with. I mean, it's one of the areas where the UK has been quite consistent and said we are going to stick to the European rules. You know, the UK has enshrined GDPR in its national legislation, so even when it leaves, the same rules will apply. The ICO has been quite vocal about wanting to keep a special relationship with all the other supervisory authorities and have a seat at the table, even though there's no kind of provision for that. So it's not an area where people are saying, oh, let's leave and do whatever we want with data. There's no equivalent of the NHS, £350 million bus driving around saying, let's start, unprotecting all this data we've been protecting. It's actually an area they're being relatively consistent, saying, well, whatever happens, we're going to, we want to push for adequacy, and so we want to stay the same. So I think it's, maybe not everyone's most important thing, but I mean, services are a huge part of the economy. Most of the data flows between the EU and the UK, so it's a big area to, for business to ease data flows.
Yeah, I think the bigger issue is really how the EU feels about it. You know, from our perspective, it's we obviously want to maintain that free flow of data for UK economy and business purposes. But you know, if the EU doesn't afford the same level of importance to it and doesn't grant or believe that the UK is an adequate jurisdiction from a data protection perspective, you know, because of law enforcement disclosures and so on, then that's where we get into trouble.
Yeah, but I mean, personally, I think it's a bit of a farce to think that we're completely fine and safe and adequate, and then suddenly on the 12th of April, that's going to change. Like, nothing's going to change in practice, is it? Yeah. I know, you know, the law says if you're not a member of the EU, then you need protections in place, but you know, I don't see anything in practice changing in the event, you know, once the UK leaves the EU in practice. So I know that, you know, that they have to view it like that, but really, I mean, what's going to be the difference? Are people going to massively start changing? Because they still have to comply with the UK law, which is essentially going to be the same.
Mm-hmm. So you both mentioned data flows there, and it sounds like under scenario A and B, for largely things will stay the same, aside from, you know, companies needing to plan for an eventual Brexit. What's the transfer situation in a no deal situation for companies, particularly for US based companies?
Yeah, I mean, international transfers is going to be one of the most major impacts in terms of data protection post-Brexit. So the situation is that once the UK leaves the EU, it becomes a third country for the purposes of international transfers of European data. So the UK will become subject to precisely the same restrictions on data exports as apply to any other non-European country. So if we can talk first about UK data transfers outside of the UK, because that's quite like an easy issue to deal with first, and then we can talk about European data transfers. In terms of UK data flowing out of the UK, the GDPR will cease to have direct effect in the UK. But the UK has enacted legislation, the EU Withdrawal Act 2018, and that preserves European GDPR standards within UK law. And as part of that, in terms of international transfers, it's preserving all of the adequacy decisions of the European Commission on a transitional basis. So any transfers of UK data to European countries or to any of the adequate jurisdictions will continue to be the same as it currently is. So no need for a further data export mechanism. Also, what the EU Withdrawal Act says is that it's going to recognize the European standard contractual clauses under UK law. So those can be used for transfers of UK data to the non-adequate jurisdictions. So I guess the only wrinkle is if you are transferring UK data to a non-adequate jurisdiction, you might need two sets of standard contractual clauses to cover, you know, UK data and then to cover European data. But otherwise, it's probably likely to stay the same. In terms of UK data to the US, the US Department of Commerce has confirmed that the Privacy Shield will continue to apply for transfers of UK data to the US. And the only change you need to do for that is to update your Privacy Shield notices and specify that, you know, EU and UK data is protected under the Shield. I guess there's one other thing I want to say about adequacy decisions. So in countries where there's been an adequacy decision by the European Commission, it's typically because those countries have their own restrictions around data exports. And you know, they've whitelisted the EU as a safe place for data to be sent to as well. But once the UK leaves the EU, then we just need to be a bit careful about considering data flows from those adequate jurisdictions to the UK, because they might not recognize the UK as an adequate territory. And the ICO has been in talks to resolve this with various jurisdictions, but it's still a little bit up in the air, especially in places like Japan. So just make sure you check the local law as developments happen. Yeah, so I think we should probably talk about EU data flowing to the UK.
Yeah,
indeed.
Well, essentially, the rules as in GDPR will continue to apply. So the basic prohibition on sending data outside the EU, unless to an adequate country, or if safeguards are in place, or unless derogation applies, will all apply to the UK. So the UK will not be an adequate country, at least not initially. And derogations are hard to rely on in a commercial sense. So really, the safeguards are the only option, and that is things like binding corporate rules and model clauses. So if you're lucky enough to have binding corporate rules, great. Although there's some question of those who have been approved by the ICO still being valid, or at least those who are in the process of being approved. Model clauses, as most listeners probably know, are rather cumbersome. But essentially, it's the only realistic option for a lot of business-to-business transfers. So, essentially, you'll have to reassess your data flows if you are transferring data only within the EU and you don't think you've needed any model clauses, but then some of those data flows are actually going to the UK. That's an area you'll have to look at and possibly start putting model clauses in place for those transfers.
So we've talked about data transfer agreements. What about the wider contracting piece? Any impacts there of a no deal situation?
Well, yeah, I mean, you do need to review them for Brexit proofing.
Mm-hmm.
References to the EU will no longer automatically include the UK. We've certainly reviewed quite a few and made a few amendments to make it clear that in the event the UK does not ceases to be a member of the EU, then X and X will still apply. That's the fundamental issue, and just check the definitions, because often I've seen a lot of agreements where people just try to fudge it by saying the EEA including the UK, but it doesn't quite work when you refer to the EEA and it doesn't include the UK, I think. But it makes sense to do a quick kind of Brexit proof review, and particularly around the definitions, and make sure it's still going to work once the UK is not in the EU.
Yeah, we've already had some cases where customers for a business have been starting to seek contractual assurances, from their vendors that they are putting adequacy measures in place for the UK. And that's really quite a recent development, I'd say, in the last sort of couple of weeks. I've started seeing a few more of those express seeking of assurances about Brexit. So I think vendors in particular, especially those obviously based in the UK, are going to start needing to sign more model clauses with their customers. For vendors who are located elsewhere outside of the UK, I think customers are still going to be wanting to seek those assurances that if there are any data flows, which implicate the UK, that they're making moves to put adequacy measures in place.
Great. Guys in the room, any more?
Well, yeah, I guess so. All the nice things I said about the scenario one, a few of those will be an issue here. So
representatives, lead authorities.
So the one-stop shop, which really is a bit of a damp squib anyway, it won't really apply anymore to the ICO, because that won't be a lead supervisory authority. So if you've gone through a whole analysis and decided that the UK is really your main establishment, and therefore you've nominated the ICO, they won't be eligible for the one-stop shop once the UK leaves. So then you'll have to do another analysis and see where else your main establishment can be, bearing in mind it should be a factual analysis, not just forum shopping. Yeah, as we saw from the Google decision with the CNIL, they thought Ireland was the obvious choice because they had a lot of operations there, but actually CNIL decided that France was eligible to decide on that. So one-stop shop's an issue. The representative point, did we talk about that? So so if you're based outside the EU and you have no establishment in the EU, but you are processing, if you're caught by GDPR, you need to nominate an EU representative. So if you've nominated someone in the UK, they can no longer be your EU representative because they won't be in the EU. So you'll need to, again, think about another EU one. And you should also note that there's an equivalent provision in the UK Data Protection Act. So if you're not established in the UK and yet you're caught by the UK Data Protection Act for the same reason as you might be caught by GDPR, you need to also appoint a UK representative.
Wow.
Yeah. But there are some of those representative organisations have foreseen this. So I've seen at least one who offers you like a discount if you've already got an EU one. They'll just bump on the UK one.
Yeah, and just making sure your privacy notices are updated as well to reflect, any either new data flows or new representatives, new transfer mechanisms. That's an important thing as well to remember. Can I also just talk about e-privacy? Is just something that's occurred to me because I've had a couple of questions around e-privacy directive and whether the cookie rules and the marketing consents under the e-privacy directive, whether any of that is going to change. Just to mention that e-privacy directive is a directive, and so it had to be transposed into each of the member states' national laws anyway. So currently the rules around cookies and marketing consents they just come from UK law, so there's no change there. But with the e-privacy regulations on the horizon, which are currently being debated at the European level, there is a little bit of a question mark, I guess, as to what's going to happen in terms of, the UK stance to that, because the UK may leave before, that becomes, once it leaves, or no longer be directly applicable to the UK. So there is some question about whether the UK will mirror what the e-privacy regulation says into its own laws, which is probably quite likely, or it may be free to come up with some of its own rules relating to cookies, marketing, telecommunications, data. They've always taken a bit more of a relaxed stance to those issues compared to some other EU member states. So they might see that as a way of distinguishing their regulatory environment to Europe.
So we're going to take back control by copying European laws.
The irony.
That's a good point, Yuli. Actually, we should briefly mention that the same will apply to the NIS directive, of course, in terms of it being a domestic law. So that's been implemented in UK legislation, and that will remain because it's not a regulation. I just wanted to briefly mention DPOs before we get to the half hour, because it's the same issue there. So it's not strictly that your DPO has to be based in the EU, but it was recommended as part of the Article 29 Working Party guidance, since adopted by the EDPB. And it's one of those things where they say, well, we really want you to, but you don't have to, but we do really want you to. So it is recommended, non-binding, but recommended. And it was one of the factors in that Google case, again, that the DPO of Google was not in Ireland. And it's one of the factors that the CNIL said, well, therefore, Ireland is not your main establishment. So just be aware, if you have nominated a group data protection authority in the UK, just consider whether that will still be considered valid. And if you do change, of course, lots of the countries have requirements where you have to register your DPO with the local authority. So if you move them, then don't forget to actually tell everyone that you have done so.
Yeah.
Okay. Well, I'm conscious that we're coming up on time. Any closing remarks from you, Mr. Webber?
Well, maybe two. I mean, there are a number of issues that we're throwing out there, and of course, not necessarily able to give all of the answers at this stage. But the one thing we do know is it's likely that there's going to be some kind of change. So it is a good time to be looking at your transfer scenarios, looking at your operational decisions, and working out whether whether you've taken some of those decisions in the first place. Know a number that haven't appointed their representative yet, but then just saying, if circumstances changed, what am I going to follow through on, and what do I have to change in order to bring myself into compliance when I know for sure what this new law is. And of course, the one difficulty is it's probably likely that we could see status quo for a long time yet. So if you document that and you have an idea of where you're going to go, at least you can come back to that effort and wake it up when you know exactly what is taking place with Brexit. To kind of quote my least favourite UK MP, Brexit's clearly a process and not an event, and we're still right in the middle of that process, and it'll be a while to really know how all this is going to fall out, although I'm sure you'll be seeing more news and more stories along the way.
Cool. Right, well, unless there's anything from Yuli on the phone.
I guess I don't want to end on a down note, but I just wanted to mention that, there are, most of the time these things can be papered over to some extent, but we have had a couple of situations where, the UK is a very integral part of a company's data flows. So where the UK is the contracting entity for European customers, and they have somewhat had to change their entire data flow model to avoid having to put model clauses in with every single one of their customers and so on. They've nominated another European entity or their US headquarters, if their headquarters are Privacy Shield certified, going forwards for future customers. So I just really want to say, I guess, that in terms of planning, there might be some pretty integral changes that some businesses will have to make. And so it really is, we'd urge you to kind of think about those transfers and to make sure that you're feeling prepared for what's to come, despite the uncertainty.
Great. Perhaps I'll call it there. Once again, our next webinar is on the 24th of April, not the 25th. We're going to be looking at controller processor arrangements, particularly sort of learnings on, now that we've been negotiating those for, it seems like forever, but for 18 months to 2 years and a year since the GDPR came into force. And don't forget to check out our past webinars if you want to learn about things like justifying your outbound lead generation program, controller-to-controller arrangements, the NIST directive, the Keneal decision, and some other stuff that we covered on other things. So until next time, that's all from us in Silicon Valley. Cheers.
Bye.
Bye.